So Professor Wendy Green, she's the daughter of American civil rights activists and is a trailblazing anti-discrimination law scholar, teacher, and advocate who has devoted her professional life's work to advancing racial, color, and gender equality in workplaces and beyond. A visionary, she's a legal architect of the Crown Acts, that stands for Creating a Respectful and Open World for Natural Hair Act, the founder of the hashtag Free the Hair movement and the originator of two legal concepts recognized within civil rights praxis: misperception discrimination and grooming codes discrimination. She's the first African-American woman tenured law professor at Drexel University, Thomas R. Klein School of Law in Philadelphia. Through her legal scholarship and public advocacy, she has generated historic civil rights protections for victims of discrimination in workplaces, schools, public accommodations, and housing. Teen Vogue, Now This News, the BBC World News have all celebrated Professor Green for her pioneering scholarly activism that combats grooming codes discrimination, and more specifically, this is systematic discrimination African descendants suffer when donning natural hairstyles like afros, twists, braids, and locks. Between serving as a legal advisor and expert for civil rights cases challenging natural hair discrimination, co-drafting federal and state Crown Acts, testifying in support of this legislation throughout the country, and publishing seminal legal scholarship used by lawyers and lawmakers, Professor Green's work has informed to date every legal pronouncement in the US on municipal, state, and federal levels that natural hair discrimination is unlawful race discrimination. So it is my pleasure to introduce Professor Wendy Green, and I just have to quickly just throw in there, she's from my hometown of Columbia, South Carolina. Our parents actually share an undergraduate alma mater, and she was even my older sister's freshman college roommate at Xavier University of Louisiana. So she really knows me as just the annoying little brother. But I'm excited to introduce to all of you Professor Wendy Green. So she'll take it from here and unmute herself and get started.
Okay, well, thank you so much, Bo, Dr. Smith.
That's fine.
I know you as Bo,
Right.
but not an annoying little brother, not at all. No, you're always a sweetheart. So it is so great to be with you all today, and thank you so much for the invitation. And I also wanted to thank the committee as well for implementing this week. I know this inaugural week that you all are commemorating, and also to Patrice Gray, who has been very instrumental in facilitating this virtual visit as well. So I will go ahead and get started with the presentation, and let's share my screen and make sure that you guys can see it as well. And does that look good?
Yes.
Okay, perfect. So as Dr. Smith was mentioning, my advocacy has been around hair and more broadly around grooming codes discrimination. And what I mean by that is that oftentimes when we think about our appearance expectations and policies, we really perceive them sometimes as being very harmful and harmless, or not harmful, but harmless. And what I have been doing for nearly 15 years now is interrogating the ways in which grooming policies and appearance norms really do bring about a very specific and systematic form of inequality, as well as infringement upon our personhood. And it does so through the means of enacting and enforcing appearance and grooming mandates or expectations that really bear no relationship to one's qualifications, our competencies, our performance, and our ability to learn, and should really have no bearing on whether or not we have access to public spaces. These mandates or expectations oftentimes implicate protected classifications under our civil rights laws, like race, color, age, disability, sex, and or religion, among other characteristics. And so the work has really resulted in what I call the hashtag Free the Hair mission. And that is a public advocacy campaign, an awareness campaign around the systematic and global discrimination that African descendants suffer because of our natural hair texture and our natural hairstyles like locks, braids, twists, afros, and so forth. And the work really tries to dismantle what we know as texturism, which is a race and color-based hierarchy that privileges straight hair, which is often approximated with or associated with European ancestry or whiteness, and alternatively, the debasement or denigration of what we know as coily or kinky or curly hair textures that is often associated with Blackness or African ancestry. And the ultimate goal through this work, through my legal scholarship, public engagement, activism around this issue, is to bring about legal, social, policy, as well as personal change so that African descendants around the world can freely rock our natural hair or freely wear our hair according to our personal needs and desires. I've been involved, as Dr. Smith mentioned, as it relates to the Crown Acts, but in addition to that, also litigation around this issue. And one might wonder and question, why in the 21st century are we litigating whether or not African descendants are able to wear our hair as it naturally grows out of our heads? But it is indeed a civil and human rights issue that is litigated in our courts today. And thankfully, what I will have to say is that in light of the litigation, in light of the challenges as it relates to the in partnership with the NAACP Legal Defense Fund, wherein I've served as an expert in a recent case, some of you may be familiar with DeAndre Arnold and his cousin Caden Bradford, who were basically forced to, or would have been forced to cut off their hair in order to matriculate in high school, as well as for DeAndre in order to graduate, so actually walk in his graduation. In a high school, in a school district they had been a part of since they were in pre-K. And so thankfully, what has happened through this litigation, now Caden Bradford, his cousin, is able to rock his hair freely alongside other male students because we have a preliminary injunction that enjoins that school district from enforcing a grooming policy that barred male students from wearing shoulder-length hair. And in doing so, what the court recognized is that wearing locked hair in particular, as it relates to African descendants, that it may very well, and it often does, bear a close relationship, if not a defining relationship, with our racial and cultural identity. And in that case, what I did was provide, historical evidence to support this claim that race is a very central, hair is a very central part of our racial and cultural identity and expression, and that to force these young men to cut off their hair is an infringement upon that racial and cultural expression in their schools. And thankfully, the court has agreed, and thus far, and Caden Bradford is able to attend high school rocking his locks, as you can see here, freely. In addition to that, so in light of that, basically what I try to do in the work is really situate this issue of natural hair discrimination within a broader historical as well as global context. In order for us to really understand racial discrimination and equity presently, we must take a look at the past. And so many of you may not be aware of this case. It is involving, in 1806, is involving three women that went before the Virginia Supreme Court of Appeals, which was basically the model for the United States Supreme Court. And in this freedom suit in 1806, these three women went before the court and said that they were free, or they should be free, that they were wrongfully enslaved because they descended from a woman by the name of Butterwood Nan. And at this time in Virginia, the Virginia legislature had declared that it would be unlawful to enslave indigenous peoples. So therefore, the only people who could be lawfully enslaved in the state of Virginia could be those who were African descendant or Black. And so they claimed that by virtue of them descending from a woman by the name of Butterwood Nan, an indigenous woman, and again, just to kind of give a little bit more context, the Virginia legislature also said in order for us to determine our status in the society, they would follow the maternal line of our ancestry, as opposed to the paternal line, which was the English common law rule at the time. So they declared that they should be free by virtue of being the descendant of an indigenous woman. by the name of Butterwood Nan. And what the court told them, they did declare their freedom, in fact, but in doing so, they demarcated, a really important racial nomenclature that still continues to shape our understandings of race today. They said that nature has stamped upon the African and his descendants two characteristics besides the difference of complexion. One, a flat nose, and secondarily, a woolly head of hair. Then they went on to say that in comparison to African descendants, whites or European descendants would display a brown hair, not woolly nor inclining thereto, among other physical characteristics. So you say, what does that really mean, Professor Green? What that means is that independent of your skin complexion, one could be declared free or enslavable in this context of racial slavery on the basis of our hair texture. And so basically, our hair texture has marked an individual as Black or alternatively as an individual as white. And if you were marked as Black on the basis of your hair texture, you could be enslaved or legally presumed enslavable. And on the flip side, if you had straight hair or a propensity not to have woolly hair, you would be marked as white or possibly indigenous and therefore free. So our hair texture, ever since the era of slavery, racial slavery in this country and even abroad, continues to serve as a critical site of external as well as internal racial classification. And we see this even during the eras of racial apartheid, not only in this country, but also around the world. And I will just give you a visual of the ways in which our hair texture has served as a proxy for our racial identity. In this instance, when we're talking about racial apartheid in South Africa, similarly to the United States, individuals of African descent, whether perceived or actual, they could not attend school with those who were European descendant. It would be against the law. And in this case, we are seeing a young woman, or actually a young girl, who was expelled from her private school for all white children, in large part because her racial identity was being challenged. And it was not simply on the basis of her skin complexion that her identity was being challenged, but as you will see, also her hair texture. This is a story of a real life story of Sandra Lang. Her parents, as you can see, are phenotypically appearing white, and she phenotypically appears Black.
Take a seat, please. Norm.
Sandra Lang.
What's your relation?
We're her parents.
Take a seat. Excuse me. Sandy.
Thank you. We'll stand.
The definition of a white person is a person who in appearance obviously is a white person and who is not generally accepted as a colored person, or who is generally accepted as a white person and is not in appearance obviously not a white person.
Is that clear? Come. Shake your head. Harder. Turn around. Stop. All the way. Open your mouth. Show me your teeth. Thank you. You may go. Wait.
So I share that with you because this was known as the pencil test, the application of the pencil test. And that pencil test was used pretty ubiquitously when you had individuals whose racial identity was challenged in this context of racial apartheid in South Africa. And if the pencil, as you can see, if it did not fall out of a person's head because of the curliness or coiliness of their hair texture, they would be declared African descendant or colored. And therefore would be barred from any types of institutions that were reserved for whites only. Additionally, in this context, in light of racial apartheid, that if she was declared, what she was legally declared Black, her parents would be violating the law because, again, during this era of racial apartheid, it was unlawful for individuals of different racial identities to live together. So you can understand the importance of race and understand the importance of one's hair texture as it relates to not only their racial identity, but their ability to live freely in South Africa as well as in other countries. More recently, we still see the stigmatization and the discrimination on the basis of African descendant girls as well as boys' natural hairstyles. And this is just an image from a protest occurring in 2016 that really drew a lot of international attention. You see here a young activist, Alaika Patel, who's on the right hand side or my right hand side. And she had suffered so much stigmatization and discrimination throughout her educational journey that she had been expelled from many schools in South Africa just because she was wearing her hair as it freely grew out of her head. In this context, we have Black female students. They were protesting the school's grooming policy that basically stigmatized and barred these children's hair. And oftentimes they reported that school administrators counseled them to straighten or to fix their natural hair with chemical relaxers and even chastised them if the width of their braids was larger than a centimeter. These protests were happening at the same time we saw these things happening, these grooming policies, the enforcement of these kind of grooming policies that barred natural hairstyles or stigmatized them. They were happening in the United States as well, Louisville, Florida, Massachusetts, among other states here. And also to that point, more broadly, this was going on even in Australia at the same time, where we have Sudanese, twins of Sudanese descent in Melbourne who were pulled out of their class and told that their natural hairstyles, in particular their braided hairstyles, did not represent their Melbourne school. And according to the school's grooming policy, the sisters' braided hair was deemed extreme and therefore wrong. In the United States, oftentimes we think about in terms of shortening African descendant children's hair. We may often think about Andrew Young. I'm not sorry, Andrew Young, not Andrew Young, but Andrew Johnson, who was a young wrestler in New Jersey, and the public, the world really saw that he had to cut off his hair or forfeit that wrestling match. Well, similarly, here in the United States, we've had young girls whose hair has been cut, and the cut without their consent or their parents' consent. And this is the story of True. True in Massachusetts in October of 2017 had her hair shaved, 7 years old. She had her hair shaved without her mother's permission, and the weekend day school where she was attending, informed them that the reason why they shaved her hair was because of hygienic reasons. But it was also told to her mother that a volunteer informed True that by shaving her head, her hair would grow back straight. So what this tells us is that there are these deeply rooted biases and stigmas as it relates to our natural hair textures. And oftentimes, even in that situation, it reflects an idea that if your hair is woolly or if your hair is kinky or curly, that it's bad and that it should be fixed, that it is wrong, and that it should be shorn. And this concept of having bad hair, if you have woolly or kinky or curly hair, is something that really is permeating throughout the world. We see it in Latin America as well as in the United States and throughout the Caribbean, for example. In Spanish-speaking nations, oftentimes people will call, say, naturally curly or kinky or coily hair, pelo malo, or bad hair. And they would assign a positive association with straight or wavy or loosely curled hair, known as good hair. And here in the United States, we too ascribe to those meanings. Something of interest here, this idea about our hair texture and the meaning that it has in our lives starts very, very early, starts as children. In the Dominican Republic, for example, in a study of children and their perceptions as it relates to racial identification and notions of personal and professional advancement, you see here that children often reported that a Black woman with relaxed hair, if they saw pictures of a Black woman with relaxed hair, they thought that that Black woman had greater opportunities to be an executive, greater occupational mobility and advancement than a woman who had a Black woman with kinky hair. Oftentimes, the children associated incompetency with Black women who did not have straightened hair. And so this kind of, and we can understand why. If we really look at the data and think about what happens as people are getting older and going into the workforce. A recent study by Duke's Fuqua School of Business reaffirms this idea that our natural hairstyles serve as a systemic barrier to employment opportunities for which we are qualified. These biases, as this report indicates, are rooted in a standard of beauty in many societies that is based upon white women and straightened hair. And this idea that straightened hair is professional. That is the hairstyle that should be achieved, that we are to conform to a straight hair mandate or expectation in order for us to have entry into certain workplaces as well as advancement in those spaces. The study also reaffirms that Black women with natural hairstyles were more likely to not get job interviews than, say, white women with straightened hair, white women with curly hair, as well as Black women with straightened hair. This continues in the workplace where Black women, for example, when they are applying for jobs or already working in jobs, in particular jobs, that they are told to chemically straighten their hair as a condition of employment. Black women, too, you can see from these social media posts that Black women have also been instructed to not only straighten their hair with chemical relaxants, but also to wear wigs and weaves as a condition of employment. And to not wear their naturally curly or coily or braided hair in the workplace. Black women, too, have been subjected to dehumanizing racial epithets when they have showcased their naturally curly hair texture. We see this is happening around the world where these two Black women, Brazilian actress Thais Araújo, and as well as a former Miss USA, Deshauna Barber, when they showcased their natural hairstyles on social media, what happened is that many of the observers started to liken them to gorillas and monkeys. And for those who may say, Professor Green, what does this really have to do with race? This is another example of how this absolutely has so much to do, if not everything, to do with race. Here is meteorologist Afro-Latina Corliss Ortiz here in the United States. You can see she was wearing her straight hair while working, and then she's also worn her curly hair while working. And what one of the observers sent her an email and told her, to the weather girl tonight, please don't wear your hair like that anymore. It just doesn't look good at all. Change it back to something more normal, not something that's all inward, iggy looking. So Black women are around the world who adorn their natural hairstyles are not only called these dehumanizing racial epithets, but they're also stigmatized frequently when they're wearing natural hairstyles. And their natural hairstyles are being called unkempt, disheveled, unprofessional, aberrant, radical, militant, unruly, distracting, wrong, extreme, unusual, unattractive, and unacceptable. And these types of stereotypes are being affixed to our hair starting again at very early ages. And Black women, too, are suffering from high levels of discrimination, high levels of deprivation of employment opportunities, promotional opportunities, as well as negative compensation decisions simply on the basis of our natural hairstyles, even when we are performing our jobs effectively. And so I just want to say how this can even persist, in the 21st century. Well, to give you a little bit of legal background here, one of the cases that's really central to this issue is EEOC versus Catastrophe Management Solutions. This is a case that was recently decided by the 11th Circuit Court of Appeals, and in this case we have Chastity Jones, who you see here is wearing a natural hairstyle. She's wearing what is known as curly locks. She applied for a customer service representative position, and she was actually qualified for that customer service representative position and was extended the job. Before she left the HR manager's office, the HR manager asked her if she was wearing locks. She says yes, and she says, well, you're going to have to cut them off. And, Ms. Jones is really kind of curious as to that. She says, well, I'm not saying that yours are, but they tend to get messy. You know what I mean? And I always say that Ms. Jones likely said, no, I don't know what you mean. And she refuses to cut off her locks. The HR manager tells her that since she's not going to comply to this instruction to cut off her locks, that she'll have to return her paperwork and she no longer can extend her the job offer. So Ms. Jones gives back her paperwork and she goes to the Equal Employment Opportunity Commission, or the EEOC. And the EEOC decides to take on her case and challenge the enforcement of their grooming policy, which bars, as you can see here, unprofessional hairstyles, hairstyles that are deemed excessive or unusual. They basically are calling Ms. Jones's locks unprofessional, not businesslike, and unacceptable, even though the HR manager actually told her that there was nothing wrong with her hair at the time, that it was fixed. It was not messy, but it was sort of this stereotype about the ways in which people think about Black people's natural hairstyle, that we have a unique propensity to have messy or unkempt hair. So they challenged this grooming policy as a form of, in the implementation of it or enforcement of it, as a form of intentional race discrimination. And what they really were trying to get the court to understand is that this is a systematic form of discrimination, that African descendants, both men and women, are suffering in workplaces. Additionally, that there were very unique burdens and harms that were associated, or that Black women in particular are suffering in trying to conform to straight hair expectations and mandates, which ultimately is what is occurring if you ban natural hairstyles. So what the court does in this case is that they apply what we know as an immutability doctrine. This is a judicially created doctrine that has been employed in cases, race discrimination cases, national origin, as well as sex discrimination cases that are challenging the application of grooming policies in our workplaces. In accordance to this immutability doctrine, the idea is that discrimination is only limited to characteristics that are not changeable, or characteristics that you're born with, or characteristics that only are possessed by a particular racial group. Well, I call this a legal fiction because there is no one characteristic that any racial group will possess. For example, yes, African descendants overwhelmingly have afros or afro-like hair texture, but there are people who do not consider themselves African descendant who do rock afros. And so based upon this idea, what the courts have said for nearly 40 years is that, if you discriminate on the basis of an afro, that is an immutable racial characteristic of Blackness. So therefore, that is unlawful race discrimination. But if you lock, braid, or twist that afro, then magically it no longer has anything to do with race. It's a mutable cultural characteristic. And since Title VII does not prohibit discrimination on the basis of culture, discrimination on the basis of locks, braids, twists, and other natural hairstyles that are not afros is completely lawful. And it gives employers and other actors free rein to regulate our natural hairstyles that are not afros. And also, according to this immutability doctrine, what I have argued is that it's a legal fiction that maintains forms of racial subordination and segregation and inequality in our workplaces. In addition to our schools, our housing, as well as public accommodations. It perpetuates a racial hierarchy that privileges straight hair, which is associated with whiteness, and denigrates naturally curly and coily hair texture that is often associated with Blackness or African ancestry. And also it legalizes what I call the hyperregulation or policing of African descended people's bodies through the medium of our hair, which is a practice that harkens back to eras of racial slavery and racial apartheid in this country as well as throughout the world. The civil rights jurisprudence also sanctions what I call a straight hair mandate or expectation that African descended women and girls must satisfy to prevent discrimination and harassment and stigmatization in our workplaces and beyond. And when we think about natural hair bands, we often don't think about the consequences of these natural hair bands. What basically you're telling a Black woman or girl when you bar natural hairstyles is that they have to conform to what I call the straight hair expectation and mandate. And what does that really look like? And this is something we don't often think about. How do we actually achieve straightened hair? As you can see here, starting at very early ages, Black women are having to straighten our hair with chemical relaxants that are very toxic in nature and damaging in nature. Also, we're using extreme heat styling, like as you can see here, a pressing comb, which can or a straight or other types of heat mechanisms that are really damaging to our hair and as well as to our scalps, and can really go up to about 400 or even more degrees Fahrenheit. And that is what we're applying to our hair in order to straighten it. So these chemical relaxants, as well as these extreme heat styling products. Additionally, we are also using overwhelmingly wigs and weaves in order to conform to the straight hair mandate and expectation. And what the Perception Institute Good Hair Study tells us is that 1 in 5 Black women feel social pressure to straighten our hair for work, twice as many as white women. Black women experience higher levels of anxiety about our hair than white women. And it also reports that Black women spend 9 times more money on professional hairstyling and hair products and more time on our hair than white women in order to conform to these straight hair expectations, mandates, and pressures in our workplaces and beyond. Additionally, other types of consequences of conforming to a straight hair expectation or mandate is that oftentimes when we are wearing wigs and weaves, they end up resulting in permanent as well as temporary damage to our scalps and to our hair. We are basically, Black women are experiencing extreme amounts of hair loss and hair damage because of the wigs and weaves, as well as the chemical relaxants that we are applying to our hair for sometimes nearly almost all of our lives. Some of these health-related consequences engender what we know as alopecia, a medical condition known as alopecia, as well as other types of temporary as well as permanent hair loss and scalp damage. We're also enduring, extreme chemical burns and scarring because of the application of toxic chemicals to our scalps. And I can attest to that, having suffered those chemical burns, even as a child and even throughout adulthood, trying to conform to straight hair pressures. Also, in terms of our health, the Good Hair Study tells us that 3 times as many Black women report that they disengage in exercise and other physical activities because of their hair. We oftentimes, when we are straightening our hair or wearing wigs and weaves, that when we get our hair done, we will refrain from exercising. And we know that refrain from exercising leads to other types of harmful medical conditions. Additionally, another study indicates that Black women who were surveyed are more likely to commit to professional hairstyling appointments than going to a physician. And I think that's really striking, especially for those of you all who are in the health professions. Moreover, there has been recent research around a possible link to the development of increased rates of uterine cancer, increased rates of uterine fibroid, and more aggressive forms of breast cancer among Black women, as well as increased hormonal activity among Black girls that lead to these reproductive conditions after long-term use of chemical relaxants, as well as other hair products that we're using to straighten our hair. So in sum, what we're really talking about here is a public health issue that is often under discussed, if discussed at all, and that in addition to these reproductive health consequences, as well as other medical conditions that I just cite to, that when we're losing our hair, that we're also suffering high rates of anxiety, emotional distress, and depression, loss of confidence, as well as self-esteem. And there are real costs to natural hair discrimination that we must account for. And so what I say here is that we should not place Black women and girls in this really precarious catch-22 to either have to pursue educational and employment opportunities at the risk of harming our emotional, physiological, psychological, and economic well-being. And in sum, if you care about Black women's health and girls' health, you have to care about Black women's hair. So these are some of the things that I have pointed out in my scholarship and public advocacy. And in doing so, I have advocated, again, that natural hair discrimination is a systemic form of race discrimination that our laws and our policies should be attending to. And one of the things that I've offered in my scholarship is a new definition of race, one that takes into account the ways in which discrimination operates on the ground, that oftentimes discrimination is animated by mutable characteristics, changeable characteristics like our hair texture and our hairstyles, and that our definition of race, when we are enforcing our civil rights laws, should embody this understanding. And so basically in an article that I published back in 2008, I offered that race should include physical appearances and behaviors that society historically and presently and commonly associates with a particular racial group, even when the physical appearances and behaviors are not uniquely or exclusively performed by or attributed to a particular racial group. So this definition has been used in what we know as the Crown Acts, the Creating a Respectful and Open World for Natural Hair Acts. You can see here, California was the first Crown Act that was signed into law just last year and is applicable to workplaces and schools. And it is amended their, this Crown Act amends their education code and labor code with this clarifying definition of race for the purposes of our civil rights laws. Other states have also followed: New Jersey, New York, Maryland, Colorado, and even Virginia. Virginia now has the Crown Act, and I believe it should be effective. Other states, almost half of the states, at least last legislative session, did introduce a version of the Crown Act or parallel legislation. Resolutions have been approved throughout the country in Cincinnati, Ohio, Columbus, Ohio, Birmingham, Alabama, as well as in Kansas City, Missouri, most recently. Also, another victory, just a few weeks ago, the Federal Crown Act was passed by the United States House of Representatives. And as Dr. Smith mentioned, I had the privilege of also co-drafting this legislation. And if it is passed by the full Congress and signed into law by the president, then what the Federal Crown Act will do is that it bans discrimination on the basis of characteristics commonly associated with race and national origin in workplaces, housing, public accommodations, and federally funded institutions. Also recently, we have the American Bar Association, which has endorsed the Crown Acts, as well as parallel legislation. It has also called for lawyers and judges and those throughout the legal profession to review their discrimination policies and provide implicit bias training to eradicate discrimination on the basis of the texture, style, or appearance of a person's hair. And this is in large part because of the wide levels of support that the Crown Act and legal interventions have have made. And so just to final thing to talk about really quickly in terms of civil rights law and policy is that it's not only resulting in the Crown Acts, but also really groundbreaking enforcement guidance by state enforcement agencies like the New York, or state or local enforcement agencies like the New York City Commission on Human Rights, which was the first to publicly declare, municipal enforcement agency to publicly declare that natural hair discrimination constitutes race discrimination in workplaces, public accommodations, as well as private and public schools. So what does this mean? In sum, is that basically all of these legal interventions are really clarifying that all forms of discrimination are animated by perceptions, biases, and stereotypes associated with both mutable and immutable characteristics. And they're really a real force in equalizing civil rights protections, not only for African descendants, but for everyone who may suffer race and national origin discrimination on the basis of mutable characteristics or changeable characteristics like our hair texture or our hair color or the ways in which we may dress, for example. This legislation and other legal inventions also really respond to nearly 40 years of federal jurisprudence that has permitted the lawful deprivation of employment, education, housing, and access to public accommodations on the basis of race-based characteristics. And I would be remiss if I did not say that this legislation, as well as other legal interventions, have largely been driven by African descendant women, activists who are really responding to the very acute harms that Black women and girls suffer due to this hyperregulation of our bodies via our hair. And overall, what is often left unsaid is that these types of laws, similarly to the Civil Rights Act of 1964, amongst other types of anti-discrimination policies and legislation, is really dismantling not only 40 years of negative legal precedent in this space, but dismantling centuries, almost four centuries of lawful discrimination on the basis of our natural hairstyles, whereby African descendants have been lawfully enslaved, excluded, segregated, and dehumanized on the basis of our natural hair textures and hairstyles. And so in sum, it's 2020. And of course, I believe that it is more than time and beyond time to free the hair.
Thank you so much, Professor Green. I mean, it is really astounding, the connections to so many different things. We do have a couple of questions that I want to pivot to you, if that's okay.
Sure.
We have some comments also that I want to highlight. One participant highlighted that being in the pandemic has forced a lot of Black women out of salons. And so they became natural during COVID and have had concerns about how they would be viewed by their employers as a result. Thankfully, this particular person's supervisor hasn't said anything, but just bringing that to light, that how the pandemic has even more effects along lines of racial discrimination than even just kind of traditional health that we think about. So I don't know if you have comments there or something to elaborate with that at all.
Oh, yes. There have been plenty of people who have posted on social media, for example, about their reconnection, if you will, to their natural hair texture, and really trying out natural hairstyles for the first time. For some in their lives, right? Because they're unable to go to the hair salon. And so you are seeing a resurgence, whether it was voluntary or involuntary, a resurgence of natural hairstyles that Black women in particular will be wearing. And I think what this legislation does, it really helps to educate individuals, supervisors, for example, to really sort of attend to possible or potential biases that you might have as it relates to natural hair textures. And I think what this pandemic does, like double fold, is that it really forces people to honestly really concentrate on what's most important. It's not about what is on top of our heads, but what are the competencies and skill sets and talents that are flowing from our heads. And so I think the pandemic has done at least something good in that sense, is that it has, on the one hand, allowed African descendant women and girls to be able to really connect to a very critical and fundamental part of our identities, i.e. our natural hair texture, and also trying to basically free them possibly from some discrimination that they might otherwise suffer if they were in the physical workspace. But we hope that that continues, that
Sure.
discrimination when they do enter the workplace.
So we have another question that says, what can be done by white and non-Hispanic people to support and stand up for those being discriminated against?
Well, absolutely. Well, hopefully this provides you with at least some new insights and education about the harms of natural hair discrimination, about the harms of even so-called neutral grooming policies that mandate that you have to have professional hairstyles, or even if that's not a part of your policy, that sometimes this is like an informal type of requirement or expectation, and it ends up being enforced disproportionately against people of color, right, who are not conforming to Eurocentric norms of professionalism. And one of those is by donning our natural hair texture. So things that people can do is that if you're having conversations, say in the hiring stage, for example, and someone makes a negative comment around someone's natural hair texture, you can actually speak to that and say, hey, didn't you know that there are states states and municipalities that are now expressly clarifying that that is a form of race discrimination. You can also shift that conversation to, like, let's not focus about something that has absolutely nothing to do with that person's competencies, and focus on what is truly most important. Are they qualified? Are they able to do the job? So that's one way that you can do it in sort of that immediate circumstance. More broadly, you can educate others about not only the Crown Act, but also this form of discrimination. And you can do that through your social media platforms. You can do that by going to thecrownact.com and signing a petition in support of the legislation. You can also do that by contacting your local and federal representatives, because this legislation may be, well, Virginia's already passed it, but if you're not in Virginia, you can offer your support there. And actually, you can offer your support with the Virginia legislatures for the federal bill as well, because it has not yet passed the entire Congress. So those are just ways in which you can get involved. But education, agitation, and advocacy are key.
Awesome. I know one question that's not in the chat, and we have a few more that I want to get to, but I want to bring this up because I've heard it expressed by students, and I've been in the dental education space for a while, and I've also been a student. And just as an African American, I have sisters and mother and daughters and things of that nature, and a wife. And you attended Tulane, which is a majority white institution for law school. How do you advise folks to maybe advocate for themselves in a educational space or workplace, particularly around the curiosities around Black or natural hair? Can I touch your hair? Is it okay if I touch your hair? And then we delve into microaggressions, of course. Oh, it's softer than I imagined. What are your thoughts around that and how to kind of have advocacy for oneself?
Right. Well, that is very much a personal kind of decision in terms of how you may engage those either microaggressions or those incursions upon our bodily integrity, frankly. I have often used the curiosity as a way to educate individuals about my hair texture. Actually, I was just talking with Patrice earlier today about a colleague who said, I was wearing my hair naturally curly, because back when I first started transitioning to natural hair, it was easier for me to maintain straightened hair, especially when I was traveling, because that didn't require me to have to take all of my hair products with me on the plane. I mean, sometimes I would literally have to check a bag because, when you go to a new city, you can't just rely upon the CVS having your creams or your oils or whatever, right? So this is something else that goes into natural hair bias and discrimination. And so I say all that to say is that I would wear my hair straight to try to relieve myself of some of those anxieties. And then I would come back to school maybe one day with straight hair, and then the next day I'd wash it and it would be curly. And I remember my colleague asking, like, well, how did you get your hair like that? I mean, I like it, but how did you get it like that? And it was like Beyonce line. Well, I woke up like this. And he's like, what? I don't get it, because in his mind, straightened hair was the norm, right? And that he thought that I was like him in the sense that, my natural hair growth pattern was straight. And I had to educate him that no, in fact, it is curly. This is how it looks. And let me explain to you what it is that I have to do in order for it to be straightened, right? So we oftentimes sort of assume that people understand this difference. And I say it's a positive difference. And this is something that we may have to educate people on, and it may make for uncomfortable conversations, but I think it's important because they're enriching and they're enlightening and can hopefully help them to possibly diminish ideas about like what we see even in the court cases. Oh, this is something that is easy, right? For you to just change your hair, that's just something that's easy. That's not anything that's harmful to you if you just have to change your hairstyle. But in fact, it can be very harmful. And I hope that this presentation and your continued education around this issue helps you to really be able to communicate that to people when you have those types of encounters.
Awesome. Thank you so much for that. A couple of other questions that we may have time for. One participant, how does the Crown Act apply to careers in the military?
Okay, so well, actually, it would not specifically apply to the military, but the good news is that even before there was a Crown Act, that the military had already undergone changes as it relates to their grooming policies, in large part because you had service women, African American service women, who were challenging their bans against natural hairstyles that overwhelmingly African American service women were wearing, and we can understand why they were wearing braids and locks and twists, especially if you're overseas and you are dealing with what I call a hair desert, where there's no place to get your hair done, and frankly, you don't even have time to even be concerned about your hair, and nor should you. But in order to be in conformity with their stringent grooming policies, Black women would wear, these natural hairstyles, but they were being banned. So there was a lot of advocacy on the part of African American women, and then service women. And they actually filed a petition with the White House. Unfortunately, it did not reach the desk of then President Obama because it did not have 100,000 signatures. So this is why you got to go out there and sign the petition for the Crown Act. But what happened was it changed the discourse, right? Because again, it was educating those decision makers, those policy makers about why we have worn our hair this way, why it is related to our history, our traditions as Black women, and the kinds of harms that you're imposing upon us when you are banning our natural hairstyles, right? For example, my sister is a retired colonel in the Air Force. And, for almost 30 years, she was conforming to what was effectively a straight hair mandate or expectation. And in the presentation, I have a picture of her where she now has a permanent bald spot in the middle of her hair because she, for those long years of conforming to straight hair expectations and mandates. And when she decided to transition during her last part of her tenure, she was the only Black woman on that Air Force base. And she would often get, harassing treatment by her coworkers about her natural hair. Like, why do you want to wear it like that? And so imagine, you're also being subjected to discipline, right? And possibly, suspension or some type of expulsion from the military at that time. But one of the great things about it is that we also had the Black women of the Congressional Black Caucus who educated. Again, they sent letters to then Secretary Hagel, educating him about how natural hair bans was a form of intersectional discrimination, not only simply on the basis of race, but also on the basis of race and sex as it relates to African descendant women. And today, now all women can rock their hair freely. You have white women who are wearing braids freely. You have Black women who are wearing braids and locks and twists and their afros freely in the military, and that's because of their advocacy, their public advocacy around this issue to dismantle, frankly, an almost 40-year policy in the military.
Thank you so much for that. One question is, do we see these types of issues or bans also creep into style of dress or other types of superficial stereotypical areas?
Oh, yes, yes. No, absolutely. It does result. I did not have enough time
Sure,
today to
yeah.
talk about it, but we can continue the conversation. But absolutely, in my work, I really show how that not only the Crown Act really does clarify, again, if you look at the definition, it's not limited to natural hairstyles or protective hairstyles, but those are just examples of the kinds of characteristics that have been associated with race and have brought about systemic discrimination in our workplaces. So, for example, you have Black women who have been discriminated against because they have worn blonde hair. And that immutability doctrine that I was talking about has been applied to those cases. And what they say is that your hair color is not an immutable characteristic. So therefore, that does not amount to race discrimination. And what I've argued is that the reason why Black women are being discriminated against is because of this idea that Black women cannot have blonde hair, that we can either be born with blonde hair or that only white women can have blonde hair, right? So this discrimination is informed by our understandings of race and the kinds of characteristics that are being possessed or portrayed or depicted by particular racial groups. So it should be a form of race discrimination if that is the kind of stereotype or the kind of bias that is informing that grooming policy that only bars Black women from having blonde hair but allows everybody else to have blonde hair, for example. So in a case like that, a situation like that, then the Crown Act would absolutely apply. If you're wearing, or donning certain types of dress that are associated with your racial or your ethnic identity, and you're discriminated against on those grounds, regardless of your racial or ethnic identity, then you too would be protected under the Crown Act and like parallel legal interventions. Moreover, my last thing I'll say about the enforcement guidance in New York City Commission, the New York City Commission on Human Affairs really helps to really clarify for us too, is that, this discrimination is not just happening on race grounds, but also on religious grounds too. And so if a person, for example, is wearing a hijab, and again, another grooming, there are lots of grooming regulations around religious garb. And if they're discriminated against on those grounds, that would be a form of religious discrimination. And in some instances, natural hair discrimination can too be a form of religious discrimination if it's associated with your religious beliefs. So what this law basically does is really helping to illuminate the ways in which our grooming regulations and appearance regulations implicate not only race, but also other types of identity characteristics that animate discrimination and protects against those very ubiquitous forms of discrimination in our workplaces.
Awesome. So robust and so touching so many topics. And I think you kind of delved into this question just now, a question raised, how does this affect men sometimes, or does this extend and affect men in any way?
Oh, absolutely, it does. Again, just for the time constraints,
Sure.
I didn't get into a chance to approach that. But yes, Black men too have been discriminated against on the basis of their natural hairstyles, like locks and braids and twists and afros. We also have cases, and this goes to the health related part, where Black men have challenged, no beard policies or no facial hair policies, in large part because, as research and anecdotal evidence tells us that Black men are more likely to suffer from PFB or those severe razor bumps when they are shaving or having to remove their facial hair. And so they have challenged those types of policies as a violation of Title VII's prohibitions against race discrimination. And in some cases they have been successful. More recently they have been. They also have challenged them successfully under even the Americans with Disabilities Act, which prohibits discrimination on the basis of perceived medical conditions or actual medical conditions that so this form of natural hair discrimination, or things as it relates to appearance more broadly and our hair texture, has definitely been challenged by Black men. But unfortunately, as it relates to natural hairstyles, their cases too have been unsuccessful, even when they've challenged them as a form of race discrimination or even as a form of religious discrimination. And so this is why the Crown Act and other types of legal interventions are really important, because it helps to redress this lack of civil rights protection that has occurred under our federal civil rights jurisprudence or by our federal courts.
Awesome. Thank you so much. I think maybe the last thing I'll just ask you to touch on briefly, some in our audience are private practitioners. So they're not in the higher ed or education space. They're not dental students, but they're actually practicing dentists who maybe perhaps own their own practice and are doing hiring and firing and interviewing candidates for positions. Is there any insight you would offer them along the lines of when they start to talk about professionalism, what that looks like, neatness? There's other words, I guess, that could be coded for things, or even also, I think a lot about like tattoos and how visible tattoos may be, or piercings may be, particularly in a dental world where things are often aesthetic. Is there any insight you offer around to make sure that we are doing what is legally prudent, but also not just legally prudent, but what's ethically prudent, which often is a higher caliber that we're holding ourselves to, or standard we're holding ourselves to?
Right. And I think it's really important that you point that out, because in some, again, you may not be legally required, right, to hire someone with, say, a natural hair texture, or if they have a piercing, which may too be related to their religious observances. So that's another thing to kind of think about, that sometimes, you know, these things are very well implicating our civil rights protections, but in other instances, they may not be. And even when they're not be, even though you may not be legally obligated to hire someone who may be donning certain types of characteristics like natural hairstyles, I think if you are really very serious about diversity, inclusion, and equity, this is something that you really want to interrogate and really examine more deeply and be introspective about. How often is it that, you know, you might be hiring people who tend to look alike, right? And especially even though you may be hiring, say, many African descendant women or men, how often are you hiring someone who looks different from the other Black woman? Are all the Black women looking alike? Are they all wearing straight hair? Are they all wearing their hair pulled back and not in natural hairstyles? And it's not to sit here and say that you should only hire women with natural hairstyles. That's not what I mean either. But what I'm saying is that, you know, do you see a diversity as it relates to those that you're hiring? Moreover, are those types of biases, maybe conscious or unconscious in nature, are they really barring you from hiring, you know, the individuals that you have marked as truly qualified and competent to do the job? Is that serving as a barrier to your mind in your decision-making process? And I think you have to be very introspective about that as you're hiring, trying to note if any kinds of patterns or practices as it relates to that. And then finally, if you do have a grooming policy that you're trying to enforce, what were the reasons for that policy? Was it really trying to, and I know this is a hard question to ask yourself, right? Because we don't want to think about ourselves as discriminators. But to be clear that anytime you discriminate or you regulate, anytime you're regulating an individual on the basis of their physical characteristics, like hair, for example, it is discrimination. You are discriminating, but you want to figure out why. Is it because, you know, this is what you've always seen, you've always thought was meant to be professional? Well, maybe this is a time for you to really rethink that, rethink your understandings about what is professional. And again, getting to the heart of the matter, which is really about whether or not this person can effectively perform the job at hand. And so those are, you know, I know it's hard to do that real hard, critical introspection about why you have the policies and why you may be enforcing them the way that you have. But I think it's really critical if you're really very committed to bringing about greater diversity, equity, and inclusion in your workplaces.
Thank you so much. This has been such a pleasure and so rich. I think that's really what we have time for today, and I want to be respectful of your time as well as the attendees. It's so rich, and I believe you're also working on a book that will at some point be out and available around a lot of these issues and topics. And so I think it was really just the cherry on top of our week where we delved into so much and talked about so many different things, but to really end with this robust knowledge piece. And I'm a history buff, so all the history you provided is super rich as well, and helps us. I mean, in the medical field, we take medical histories, right? And we do that purpose because that history connects to present day. And so I think sometimes we forget about how that is so important for other areas as well. So thank you so much. It's been such a pleasure to have you, Professor Green. We really appreciate it. I did post in the chat if you want to look at the, someone asked about the petition. So I posted a link to that. And I also posted a link to your freethehair.com website, which has a lot of information as well.
Thank you so much. I so
Thank you so much.
Okay, thank you.
Everyone have a great afternoon.